information that you may deem to be useful in us making a correct decision. So including that that legal opinion that you mentioned, that would be very, very welcome. Siyabonga Hlomuka. We thank Salga for your input. Thank you. You can now unshare your presentation. Colleagues, we're moving on to the last presentation of the day. It is a presentation now by the City of Tshwane. The presentation, I understand, will be made by Mr. Ndomato Muchiza. I'm not sure. I think he may be accompanied by somebody. Can we see you, sir? And maybe you can confirm. Apologies. If you are making the presentation on your own or you're making a presentation accompanied by somebody, so we can swear both of you. Moga, if you can unshare your presentation so we can allow City to also share its presentation. Thank you. Mr. Muchiza, would you object to taking, or firstly, can I get a clarification? Are you presenting on your own or are you going to be assisted by somebody else so we can swear both of you if there's somebody else? You are on mute, sir.
Good morning, the members of the regulator and the other colleagues from Eskom and Salga. It will be myself and Dr. Manganye that can be swear in to take the oath, so that we can then be able to provide a response and not only wait for him to be swear in when we're going to questions in that instances.
Okay, thank you. Let's start with yourself then, Mr. Muchiza. Would you object to taking an oath?
No, I have no objection to take an oath.
Okay, in that case, kindly raise your right hand and affirm the following. Do you solemnly declare that the evidence and the information you are going to be providing to this panel is the truth and the whole truth?
I do.
For the record, please state your name, the organization you are representing, and your designation therein, please.
My name is Ndwamato Tom Muchiza from the City of Tshwane Metropolitan Municipality, the acting group head, in the correct terminology, the head of energy and electricity in the city. And I'm here to make the presentation as stated. Thank you.
Thank you, thank you. Can we also then swear in Dr. Manganye, if you can show yourself, sir? For some reason, it's not allowing you to show your picture. Oh, okay. The other one does. Okay, thank you.
I can't
All right.
share.
So, yeah, no, we can see you now. Can I ask a question? Would you object to taking an oath? You are on mute, sir. Dr. Manganye, you are on mute. Oh, okay.
No objection, Chair. I don't have any objection to take an oath.
All right, thank you. In that case, kindly raise your right hand and affirm the following. Do you solemnly declare that the information and the evidence you are going to give to this panel is the truth and the whole truth?
Yes, I declare, Chair. Thank you.
For the record, please state your name, the organization you are representing, and your designation therein, please.
My name is Francis Manganye from the City of Tshwane Metropolitan Municipality. I'm the Divisional Head of Electricity Planning and Provision in the City of Tshwane. Thank you.
Thank you very much. Okay, over to both of you gentlemen, whoever's making a presentation. You can now switch off your video if you so choose, but you can still keep it on if you wanted to. Do we have the rights to share a presentation?
It looks like it's deactivated, Chair. We will appreciate if we can be allowed to share the presentation. Thank you.
Mr. Mateja?
Yeah, he's been given the rights, Mr. Kumete.
Yes, okay. Mr. Muchiza, if you can please try again.
Chair, on my side, I think Franz is given the rights. It's fine. He will share it.
He will drive it. Okay. Thank you. Thank you.
And for record, Chair, can then I allow that because he's got to drive it in the presence, can he then continue to present and then we will respond? Thank you, Chair.
No, thank you, Tommy. In fact, because both of you have been sworn in, you can share equally. Mr. Mangani, say you've got 20 minutes, as you know, for the presentation, and you'll be given a further 10 minutes, both of you, to respond to the questions. And your 20 minutes starts now. Thank you. You are on mute, though. You're on mute, Doc. I think you've unmuted yourself now. Please, can I hear you? Can I see if I can hear you?
Yes.
Okay.
Yeah, I've unmuted myself. Thank you very much. I was just saying greetings to everyone in the meeting. I will be taking through the committee on the seat of Tshwane presentation. Firstly, Chair, we are indicating that as part of the local government priorities, we make sure that we are attending to the developmental roles within the boundaries of the municipality. And of course, what we do in ensuring that we fulfill our developmental roles is to ensure that we apply the policies within the municipalities, and of course, any institutional framework that supports the development of the municipality in terms of different legislations applicable. And of course, we also indicating that, Chair, in terms of Section 115, 1A of the Constitution, I think as indicated earlier on, the municipality has got both the executive and legislative authority within its area of jurisdiction. And of course, amongst others, it includes, it's included under Municipal Structures Act as well. And furthermore, Chair, we also indicate that the municipalities, as part of those executive and legislative authorities, we need to address issues that are listed under Part B, Schedule 4 of the Constitution, as well as Part B, Schedule 5 of the Constitution, of course, which they indicate that the regulation of electricity is within those schedules, and they fall within the jurisdiction of the municipality. As part of the City of Tshwane mandate and responsibilities, especially in terms of the electricity distribution license that we have been issued by NERSA, we are indicating that we need to ensure that we provide the distribution facility in the area that has been referred to in Schedule 1, and which is included in our electricity license as the city. And of course, we also have to ensure that we distribute such electricity provision to all our customers within our license area, and at the same time, the customers must be supplied all potential customers, we need to ensure that we provide electricity in accordance with our electrification plan. And in this case, we are referring to our electricity master plan, which details the provision of the electricity in the entire area of the city in line with the special development framework of the City of Tshwane. And of course, at the same time, we shouldn't discriminate any customers regardless of either the tariffs or prices, and of course, any conditions except to objectively justify and identify the difference as approved by NERSA in this case. And of course, we need to ensure that we don't, there are no non-discriminatory access of electricity. And of course, in this area, we want to ensure that even this mega development electricity provision is being supplied to the area as well. With reference to Section 16(1)(b), Chair, of the electricity regulation, permission must be sought from the licensee in case there is an amendment of the license. And we also want to indicate, Chair, that as the City of Tshwane, we have not as yet given that permission for our license to be amended. And I think lastly on the slide, Chair, we are indicating that as the City of Tshwane, we have indeed been issued with the electricity license, and then this area that we are contesting or is under consideration, which is Rietfontein 7375 JR, which is a farm portion, is also included, Chair, on our Schedule 1, which has got is is listed as number 1926. So we are saying, Chair, this area is included within our electricity license, and as such, there is no need as the city to apply for it to be, included, because we do have it already. So there's no need for it to, for a city to apply for it to be amended, for the license to be amended, because, as I indicated, it forms part of what has been approved by NERSA within our electricity license conditions. And furthermore, Chair, we also indicated the mandate and responsibilities of the municipalities, which we have to ensure that the security of electricity supply to residents is provided. And at the same time, we need to ensure that we provided reticulation services in a sustainable, effective, and efficient manner. And of course, this will also be assisted by ensuring that the area under consideration is also, being supplied by municipality. Strengthening of the electricity network infrastructure is also one of the areas that we take serious as the municipality, to make sure that our infrastructure is capacitated, strengthened, and amplified to cater for all the developments in the city, in line with the spatial framework of the city as well. The provision of electricity and public lighting services is also what we ensure that we have to provide to our residents as the city, and also to ensure that we promote sustainable power projects through entering into applicable power purchase agreements, and in some instances, of course, the wheeling agreements within the alternative energy producers within the demarcation of the city. Compliance with regulatory mandates relating to quality of supply, more especially NRS 047 and 048, are also one of the key responsibilities that we ensure that as the city, we make sure that customers and what we provide as part of electricity supply to our customers is of quality in nature. The slide, Chair, that is before us indicates the electricity supply overview within Mooitloof area. And as indicated, Chair, on the slides, you'll realize that the cycle indicates the demarcation of electricity infrastructure within the area. And currently, we have got a substation called Mooitloof within the area. Next to it, we have got Mooiplatz, which is the substation that we have planned in terms of our electricity master plan to ensure that it accommodates the provision of electricity within the development of Mooitloof mega city. So at the same time, the resources ability, we have to make sure that we made them available. And we have done so to make sure that there is capacity that is adequate from the city point of view to supply electricity into the development as well. And I think, Chair, we also indicated the city that from our point of view, the area it's a greenfield in the sense that there are no any other electricity or reticulated services within the development, because it's a new development, which I think we need to provide electricity of. And at the same time, there won't be any issues in terms of concerns of island, because we are able to ensure that there are clear demarcation of areas between different roles of electricity provision in different areas. And as we can see, Chair, we're at an advanced stage as the City of Tshwane in terms of our planning to make sure that we provide electricity within this area. And at the same time, we're interacting with Eskom, because they need to, as we all know, they are responsible for the generation of electricity and the high voltage, the transmission of electricity. And we have applied as well, follow the necessary processes to make sure that we apply for the capacity that is required to provide and ensure that we reticulate electricity in the area. The next slide, Chair, just indicated high level, the area under the development. And this is the area that we are saying as the City of Tshwane currently it's a greenfield. And we are planning, and our plans, as a matter of fact, they are at an advanced stage to make sure that we provide electricity in this area. And we will indicate that in the following slide, which you can see, it's Veldes in-feed station, which is one of the bulk substation that we have identified. We are busy working in making sure that we provide the bulk adequate electricity in the city. And Chair, I must also indicate that we have already paid the codes that Eskom provided to the city. The first one being the feasibility quotation, which we've already paid years ago to Eskom as the City of Tshwane, followed by the cost estimate to provide the station we've already paid. And I can also indicate that last week we've received the budget code from Eskom to make the necessary payment to make sure that we can be able to bring this infeed station on board. And it's part of us as the city to provide electricity in the area as well. And Chair, we are indicating that our electricity is bulk electricity currently is tightly constrained, and hence we have applied for this additional capacity from Eskom. And in terms of our plans, we have indicated that we're anticipating to commission this bulk primary station around 2025, which I think through the plans that we are working together with Eskom, we should be able to reach that target date. And the commissioning of this infeed station will relieve capacity from some of our infeed station in the area, including Nyala infeed, and of course to make sure that there's adequate capacity of electricity to supply Mooikloof mega city as a development, and of course, which I think from what we have received from the engagement with the developer, we are looking at about 15,000 units. And lastly, Chair, on the slide, we are indicating that it should be noted that this arrangement will also relieve capacity on the power lines that we have in the area, which is Nyala and Mooikloof stations. From just to be specific, Chair, Mooikloof substation is a substation that is in the vicinity of the area. We are indicating it as a capacity of 105 MVA, which is a firm station. We are saying it's located within 4-kilometer radius from the development, and currently, Chair, it's running or operating at about 35%. And of course, this shows that there's a difference from 100% that can also be considered to be allocated in some of the developments within the area. But unfortunately, this substation, Chair, suffered fire in 2021, and we are currently working on a plan of refurbishing it. And soon we'll be handing over site to the contractor before the end of this month to make sure that process kick off the ground. And this substation, Chair, will have adequate capacity to supply part of phase 1 and phase 2 of the development once it's been fully commissioned. And of course, the remaining part of the development or the demand, if it won't be catered by Mooikloof substation, it will of course be covered within the other supply areas like Nyala power line, which will be originating from infeed Nyala station as well. Chair, in terms of the financial impact, as the city, we have sit down and look into the impact that this development will be, impacting the city, and we are saying there is a potential source of income that this development will be able to generate. And of course, we need to make sure that we don't lose that as the city. And from electricity generation point of view, we generate most of revenues from all the utility services, meaning all the customers that we are connected to the electricity regulation. As the city, that's how we generate revenue, and that's how we make sure that as the municipality we're becoming sustainable and to be able to provide services even in other areas of the municipality. And Chair, we are indicating as well that from our initial or desktop calculations, what we have determined is that approximately 125 million rand per month, it will be the revenue loss for the municipality if we are not allowed to continue, or if we allow Eskom to amend their license to include this area within their electricity license. So as the city, we are not in a position to lose this revenue, which is something that we're looking at it. And we know that once that revenue comes to the city, it should be able to assist the city to perform other functions within the electricity space as well. Chair, in our conclusion as the city, we are saying that the city is not willing to cede, to transfer and assign its license or any such power or duty to Eskom. So we are not in agreement with the city for the license of Eskom to be amended, especially on the area that is within the electricity license of the city, as I indicated in the previous slides. And at the same time, Chair, we are saying the electricity infrastructure plans of the city does cater for the provision of electricity in other parts of the development. So What we are simply saying is that this development or this area, it has been included in our electricity master plan, and as such, it will be accommodated within the plans that we have of the city to provide electricity. The city as well has invested in infrastructure provision in the development and the area, and the sustainability of municipality, as we've indicated earlier on, is normally based on the revenue that we have collected, and therefore the city is not willing to lose any anticipated revenue from this development, as I earlier alluded to. And of course, the city reserves the right as a municipality, as the executive and legislative authority in its area of jurisdiction, to reticulate electricity in line with Section 155 of the Constitution. So as such, we are saying we are not in agreement. We need to be allowed, because we are mandated by the Constitution to provide those services within our residents as well. And of course, the city is not willing to compromise its executive and legislative authority, which are mandated by the Constitution and other legislations that are supporting the Constitution in that regard. And Chair, lastly, we are saying to this end, the city stands firm to object Eskom application for amending its electricity distribution license to include Mooikloof mega development within their license as issued by NERSA. Chair, I think that is the submission that as the City of Tshwane we are making. And
to the presentation. Thank you to both yourselves. I guess you will remain available if you can then take questions from members. Members, you have the presentation of the City of Tshwane before you. Yeah, start with yourself again, Madam Maseti.
Thank you, Chairperson, and thank you to Mr. Ngwanye for the presentation. Chairperson, I'm now confused with regards to the status of the area that we are talking about here today, because I hear that this area is already licensed to the municipality. In other words, it is an area that is already included in the distribution license granted to the municipality. I'm worried because, as the members, obviously staff members, we are unable to do that verification at this point in time to then see that whether or not the this area is indeed licensed to the municipality. But besides, Chairperson, if it is licensed to the municipality, and I'm asking myself, why are we here then? Because surely that should have been verified earlier on. And also the municipality should have also, should have given effect to the obligations of the license. Why are they not servicing this area then? Why are they not supplying electricity if this area is indeed licensed to the municipality? What prevented them from servicing this area? That's number one. And then the second thing is, it seems here the parties, the service providers, are only worried about themselves and the revenue that they are likely to generate out of servicing the customers in this area. However, there is no due consideration on consumer protection here, insofar as their rights to access electricity. So if you have a license and you take your time and you don't do anything to try and provide the services to consumers, when you are obligated to provide such services, then you sit back. But if there's competition, then that is the only time that you now wake up and say, I will also want to service this area. I'm a bit worried about that, because it goes to the very notion of monopolies, when they sit back and do nothing, even with the services. And therefore, if there's competition, that is when they suddenly wake up and also want to do something and see the value of this particular area. So I would like to hear the municipality's reaction to this observation. and also to clarify to us then as the regulator that, in inverted commas, granted them the right to supply electricity to this area. Why and when did we do that? And what has taken them so long to ensure that customers who also have constitutional rights are able to access electricity? If they can clarify that to us, Chairperson, I will really appreciate it. Now, just coming to this issue of Section 78 process, can the municipality enlighten us on this process? Was this process kick-started at all? Was it initiated at all from their side or by Eskom? And what is the status of such of that process and the negotiations pertaining to that process? And have they made it clear to Eskom that, well, this is an area that we are already licensed to service? So why would then Eskom, out of knowing that, then come to NERSA to say to NERSA, give us the right, when that right is already granted to the municipality? According to the municipality, why would it come to us and say, give us the right to service this area? The last question, Chair, relates to the municipality's infrastructure in that area. The municipality did not assist us in its presentation here today to show to us that they have made an effort, or they already have infrastructure that is almost ready, even if it's not in that particular area.
Madam, we lost you there. Madam Assetti?
Yes, Chair. Can you hear me? Chairperson, can you hear me?
You.
Oh, okay.
Now I can hear you.
Thank you, Chair. Chairperson, I was on the point of getting clarification regarding the status of the municipal infrastructure, its readiness in terms of discharging its constitutional mandate then to supply electricity to the customers in that area. Can they update us? Because they did not share any map or show us infrastructure, the network that they have, which then will at least give us a sense of how ready are they. Do they even have an interest to monetize their infrastructure or develop it further to be able to supply electricity to that area? Eskom, on the other side, it has shown us the network, and it has shown us its network is dominating in the area that is closer to the one that we're talking about. And it showed that the municipality's infrastructure is in certain pockets, not so close, according to Eskom's one. But the municipality did not even dispute that, or it has not even shared any network system, so that we can be able to see how ready they are and whether they would even discharge their obligations of the distribution license. Thank you, Chair.
Thank you, Madam. Advocate Sithole, I saw your hand up earlier, but I don't know whether you've lost connectivity, perhaps.
Chair, my hand is up. I think I don't know what's going on with my functionality of raising my hand. Yes, Chair, my hand is up. With your permission, may I ask?
Okay, please proceed. Okay, please proceed, Madam.
Thank you, Chair. Thank you, Mr. Manganyi, for the presentation. I just want to raise 2 points of clarity with you. The first one being that Eskom did indicate in their presentation that they started negotiating with the city of Tshwane in 2020 regarding this particular area that they have applied for, and that there was no agreement or resolution reached between the city and as well as Eskom. And my question of clarity is, in these negotiations, I don't know how many were held. I just want to find out if as a city, you did inform Eskom that this area, the development areas, those areas were licensed to yourselves, and also, why did you not do this if it wasn't done, only to object now in March 2022? And the other point as well that was raised, I think, in Mr. Ngiti's presentation is that as a city, you're also required to follow the Section 78 process in terms of the Municipal Systems Act. And as well as following that, you also need to get council resolution. I just wanted to find out, in terms of this area that you are now indicating that you are not intending to cede or transfer or assign to any other licensee, have you followed that particular Section 78 process? Thank you, Chairperson.
Thank you, Advocate. Madam Pongosen?
Thank you, Chairperson. I just want to pose a question to Mr. Manganyi and Mr. Muchiza. If the first one is just to find out from them if there are any firm plans in place, to supply that area, that is Farm Redfontaine. If the opportunity was presented to the city, do they have the budget, to go ahead with laying of the end user supply connectivity in the area? Is it something that they can do by, hitting the ground running if they were granted that opportunity? And the other question is that currently, Eskom has said that they currently have about 72 customers in that area. And they do have the network already that they need to supplement or expand or boost to cover the additional, the whole project. So if they can just, Mr. Manganyi and Mr. Muchiza can just tell us, how did Eskom get to be the supplier of those 72 customers in a municipal area of supply? Why is that the case? Why is the municipality not the one providing that supply to those customers that are currently with Eskom? Thank you, Chair.
Thank you. Just one question from me to both of you, gentlemen. It is clear to us that this area is contested. In one area, I think in one way you are saying that, in fact, it's not a brownfield. It's actually an area that is already supplied by yourself or should be supplied by yourself. You've got infrastructure and in that area. Eskom is indicating something similar. Now, how do you suggest NERSA should adjudicate in this case? I mean, we were supposed to work on a first come, first served principle because there is no auctioning of these areas. So I guess the question is, if we were in NERSA's shoes, how would you go about with this process? What would you suggest that we do? Again, gentlemen, you've got an option to respond to the questions verbally that have been posed to you here on this platform, but you also have an option to then respond in writing and within 7 days. I guess we have got both options. So over to you, both of you, to then you can decide who then responds to what. Thank you.
Thanks, Chair. Let me start. This is Ndwamato, or Tom Muchiza. Let me start by stating clearly that on the question that I'll try to take questions from yourself, Chair, that what is the best liquidations you expect to be done by NERSA in this crisis that we find ourselves in. And I think I need to be very clear, Chair, that when I first saw the application on the newspaper, first and foremost, I then wrote to my city manager that wrote to NERSA on the 28th. And after NERSA sent a letter officially on the 25th of March. about the application. And we were clearly indicating in the letter to the regulator that the process that we are faced ourselves now before the regulator, it has jumped a lot of process issues that need to have been done. That means that Eskom in their own space applied without having first sought the consent or the council decision as to how we must deal with this matter in that fashion. And that's why we then felt that no, who could have and I will tell you, Chair, we ought first with our legal advice was that we wanted to interdict your processes. But we then said we'll then come and present what we have written in the letter to the regulator about what the position of the city, because we felt that the process that was followed was not even aligned to what NERSA should have done, which is an internal process of NERSA, which I think as the regulator member raised indirectly, but we understand where we come from. But I think that we also need to appreciate one thing, Chair, that post-1994, Eskom survived on grandfathering processes of supplying rural townships and all those stuff, which is why even the 72 customers that are farm portion were part of the beneficiary of the 1994 processes that Eskom found itself in. When wall-to-wall municipality will then be able to be put together and the provision of the constitution come into picture. However, we already found that there's an Eskom network in that fashion, and that's why you found that those 72 customers are still there as the farmers. But these farmers, as they tend to sell their area and want to develop it into township, all those stuff, in agreement with what the city or municipality will be faced with. When we consider that aspect, that's where we then engage with Eskom to say, Eskom, you had one connection in this farm, and this farm is selling, we are buying it. Can we then convert your one connection into a bulk connection to ourselves so that we can service our customers in that aspect? And that deal with the fact of why there has been 72 customers that has been there. When the license conditions were very clear, the license says provided to the city, that area, it covered in that fashion. But the intention has never been, and our intention with Eskom has been that we must try by all means. There are a lot of areas, Chair. Alpha, to give you an example. The city of Tshwane has got both the metropolitan in the city or the townships and rural space. And when Nuke, Ntataiman and other areas will then be able to be incorporated, therefore the new licenses areas then are also cover areas that are rural and creating some islands. We already have islands areas in our own space, which together with Eskom, we agreed that move from this angle to ensure that we don't create problem in that fashion. But in this instance, per se, the 72 customers are just the beneficiary of the fact that it's a legacy aspect. It has nothing to do with the fact that we allow them to supply those customers. I think I've dealt with the fact that why we're only responding now in March. Like I said, we only received your applications of Eskom, Eskom NERSA public notification in the newspaper. And then instead of, we wrote official to NERSA to say this is our position in that fashion. And that's why there's no application. We can't apply in our space for what we've already been licensed. That's why there's no application from the city for the same area. But the engagement between ourselves and the developer has been ongoing, both from water, bulk electricity, what is required, all those stuff, and even what is required from phase 1 to phase 2 and phase 3 of the development. We have got those engagement, and that's why we said those who can then be able to come back to you, Chair, as we said, in 7 days to provide even evidence of all the engagement that we had between ourselves and Eskom and the developer in that instance as such. And that talks to the fact of why there's no Section 78. Why must we take a Section 78 when we have not, there's nothing that requires us to even go to Section 78. Had Eskom felt that it needed to apply, it will have sent an application to the city. The city will have then, I, myself, and Dr. Mangani will have returned to the council and asked council to approve for the process to start Section 78, and the basis are this. And then council will have asked us why. and we will have to demonstrate that whether we have capacity or not capacity to can do that aspect. And that's why there's no Section 78 process that has been undertaken by the city, because it does not arise in that fashion, because our engagement with Eskom was an honest engagement in terms of how to unlock. I will give an example, Chair. How to unlock the development of VLDBS to be what it required. It says it needs VLDBS as a swing station. In case Apollo go out on network to on maintenance, that it can supply Gauteng. We then said, no, let's unlock that aspect. And in the process, it will unlock all other development that we're dealing with. And that's why I said that's the engagement that we've been having with Eskom in transparently, honestly. But we then found this application on the newspaper. And when we tried to contact the members, the secretariat of the regulator, then they told us that no, this sitting, we must register on the 6th and then ensure that we come to today. And that's what we did. But in the process, we responded to our position as such. I think, Chair. Let me conclude from my response to say there's a point that the regulator need to take into confidence. There's not a single national legislation that can surpass our constitutional rights. It cannot happen. To do that, we are going to court. And that's the process that, because the Constitution gives the rights. If there's anything that's contrary, therefore the city has reserved the rights because its functions and responsibilities are assigned in the Constitution. And that's why we said there's no act that then surpass the Constitution. Otherwise, we must go amend the Constitution to give rights to that processes in that fashion. I think the rest, Dr. Manganya can respond to them as such. Thank you, Chair.
Thank you. Madam Maseti, can I allow Dr. Manganya to respond to all the questions? Then I'll give you an opportunity for a follow-up, please. If that's okay with you. Please proceed, Doc.
Yeah, thanks very much. I think the question that was saying what prevented us, the city, to provide services in the area. Nothing, Chair. Remember, we indicating that from our electricity master plan point of view, we have made provision for the capacity to be provided in the area. So there is nothing that prohibits us, except to mention that before you provide the electricity to the area or to the development, you are then triggered by township development process. And then as such, that's how you provide electricity in the area. So from our electricity master plan point of view, meaning from the planning of electricity provision in the space of the city of Tshwane, that area, we have made plans to make sure that as and when the time is ready, we'll be able to provide electricity to it, but triggered by the developers in the area as well. And I think that also covers the second question that deals with the rights and access of electricity, why customers were not provided with electricity. I think it's more or less the same thing. We can only do that as and when there is an application of electricity in the area. The question of Section 78 process, I think it has been clarified. That one you can only trigger as and when is necessary. So for us as the city, from our point of view, we are capable as the municipality to provide electricity in the area. So as such, there is no need for us to trigger, Section 78 process as well. And in terms of the infrastructure in the area, we indicated, Chair, maybe we have not amplified our voice on the slide that I'm trying to now magnify on the screen, to say we might not have presented the schematic diagrams or the line diagrams as Eskom did, but we went to the higher level. So in terms of the high level, you'll see the Mooikloof cycle. We do have electricity infrastructure, meaning the network do exist in this area. And if we have to show that, I think we can be able to show that with a further submission. And of course, we are indicating that for the development as well, in terms of our plan, we should be able to accommodate it, as currently it's a greenfield. And that is why we have planned Mooiplus to be able to be a substation that should be able to provide the development with electricity. And the engagement with Eskom 2020, in those particular engagements, we did indicate to Eskom that, look, as the city, we hold the view that the area belongs to us in terms of our license. And as such, we reserve the right to either provide electricity or outsource it if we are not able. And we indicated, to Eskom our appetite of providing electricity in the area. So we made our position very clear to Eskom, and there shouldn't be any reasons as to why Eskom did not understood. And as I indicated earlier on as well, we have been having meetings with the developer to plan the provision of electricity in the area. So from the planning side, activities are taking place, and from the implementation side, actual work will happen once all the agreement has been concluded upon, and for the electricity to be provided in the area. I think those for me are the questions that I thought I can just make some additions to, and we have got plans in place, and I think Tom answered 72 customers. I think is based on the issue of legacy of electricity in terms of the history of the country. And the last question being whether the areas are in contest or not. From our position, we don't think we are the area is in context, because it's something that belongs to us as the city. And of course, I think NERSA must then be able to apply the constitutional responsibilities as outlined in the constitution for the municipality, in ensuring that services are provided by the municipality as allowed and mandated by the constitution. Thanks, Chair.
Thank you to both of you. Madam Maseti, you seem to have had a quick follow-up, ma'am, if you can follow up.
Thank you, Chairperson. Yes, Chairperson, my follow-up was on the readiness of the infrastructure to supply this area, especially because it's interesting. This is the question I asked right at the beginning about a brownfield versus greenfield. So if this is an area that is already licensed to the municipality, I was wondering then why is there no infrastructure that is almost ready to then to supply this new development, and how long it will take. But that question is partially covered by the municipality. But again, Chairperson, now it seems to me then, if indeed these farms are already licensed to the municipality, why, and there is no, and we're not talking about handover here or transfer of those areas to another supplier, why are we here then? Because for me, that is a critical question. If we're talking about an area that is already licensed, and there is nothing to dispute that at this moment, as we are trying to hear evidence around this application or on this application, that for me presents a challenge, Chairperson, because we cannot be talking about a request to license that very same area to somebody else when that very same area is licensed, or the rights to supply that area are granted to the municipality. I am very worried about that, Chairperson, because it seems to me we shouldn't be here then, unless otherwise we have evidence also from management to at least assist the members of the regulator that are trying to get an understanding before the regulator takes a decision on this matter. I'm very worried about that, Chairperson, because I don't think that we'll be talking about any application today and set up a hearing if already the license, the area is already licensed to the municipality. I just wanted to flag that, Chairperson, because I think it is very important, and we don't have it in the documents that are before us, so that we can be able to pursue and interrogate the statements that are made here that this area is indeed licensed to the municipality based on the documentation that is before us. We're unable to interrogate it further. Thank you, Chair.
Thank you, Madam Maseti. To both yourself, gentlemen, I don't know if you want to add anything. My request would be, especially coming from the comments you've made, that unfortunately you may have read about this when you saw this advert on the paper, and therefore responded to that rather than to actually have a formal submission. Is that I would think you've noted the questions asked by members, you've noted the presentation by Eskom. I would really request that within the next 7 days, if you could, it would be useful to assist the energy regulator in making a formal submission to us in respect, raising all the issues that we've raised, but raise them formally so that we can be in a position to then make to arrive at a decision, whatever that decision would be, but it would be informed by all the information that we currently, as the energy regulator at least, the body of 9, that we do not have. So that would be very useful for us. But I'm not sure, I'd like to give an opportunity, maybe 2 minutes, if you still want to maybe add something. Samantha?
No, thanks, Chair. I think I want to take a cue from Member Maseti. That in true sense, that's why when we respond to the regulator, I thought that Dennis would have cancelled this public hearing when he got the letter from us, because our response was very clear, indicating that why are you doing that when you already know that this area is licensed to the city of Tshwane? Therefore, there's an internal problem, Chair, that the regulator must find its team to support it, to ensure that you are able to make a determination. This application of Eskom was not necessary. That's what I can say, but we will provide further to what the city manager have sent, and then be able to show to you our plan for the future, because this application is about the future. It's not something about the current 72 customers that they have that are their grandfather from the past. But we will then provide that within the 7 days with additional aspects jointly with I think I must say to yourself, Chair, jointly with SALGA, we're going to also submit clearly, indicating how we felt that the process should not even be appearing before you. Hence, you see that ours was to respond to object that application, and we're just showing why we're objecting it. Thank you very much.
Thank you, Mr. Muchiza. I muted myself there. Thank you, Mr. Muchiza, and also Dr. Manganyi for the feedback. So we'll be looking forward to any additional information and submission that you can submit to us that can assist us in actually arriving at a decision. As it is customary, I would like to afford Eskom a 10-minute right of response. It is a right that is enshrined in terms of our jurisprudence. If I'm not sure whether Mr. Sehwe and maybe Mr. Gibbs, whether you'd like to take up that right to respond. We'll give you 10 minutes to do that.
Thanks, Chair. We would like to take up the opportunity to respond. So it's 10 minutes. We will share 5 minutes between myself and Mr. Sehwe. Chair, just a few points that I want to touch on my side regarding the issue of the constitutional matter that both SALGA and the City of Tshwane have indicated. Chair, we believe that there's a process that is in place. We would not want to really dwell much into it. We will allow for the process to unfold. I understand that Eskom is also part of that process, so we will make a formal contribution as it would be approved by our board. However, we just want to make a point, Chair, that NESA is mandated by all the applicable legislations, and it is our belief that in granting Eskom the distribution license, you were not in contravention of any of the applicable legislation. And equally so, amending our license, you would not be contravening any of the applicable laws, Chair. So it is well within your powers as mandated by all the applicable laws to do that, Chair. And the second point that I want to make, Chair, is regarding the question that Ms. Maseti was asking. the city, that the area is in the city's Schedule 1. Chair, we had a similar instance with Midval. I think it was sometime last year, where the area belonged to, it was part of Schedule 1 of Eskom's distribution license. But when you look at what the GIS rules are saying, you know, the definitions in the GIS rules or the GIS principles, or in the definitions, it then resulted in 8 flag being regarded as a brownfield. The difference there and this one is that Eskom, in that particular instance, we had already made an investment by acquiring the servitude. In this one, I don't see where the municipality have made any investment. But the outcome or the decision by the regulator was to grant Midval that particular area. We came to the regulator, we objected the same way as the city is objecting, but then because the definitions in the GIS project did not favor us, then the regulator then granted Midval that particular area. We wanted to raise concerns. It was actually a gray area, which we tried to address with the officials, but we had to stick and accept the decision that the regulator had made, Chair. The last point that I want to make, Chair, is around us pre-booking the areas. Chairperson, we are guided by the rules, and pre-booking of any areas of supply, as per the licensable areas of supply rules, it is a prohibited activity. And Eskom, as you know, as a company, we would not want to be found to be wanting or be found to be contravening any of the NESA rules and any of the legislation that is applicable. So we did not pre-book this area in any way, Chairperson. The 722 customers that are there at the moment, they are still regarded as standalone customers, as catered for in the licensable areas of supply rules. So that is why we are there, Chairperson. Chair, the other points, Mr. Sukhu will cover them. Thank you so much.
Thank you, Mr. Gibbs, and thanks, Chair, for allowing us the opportunity to, engage further on this particular matter. I'm going to first start with the NDP process, or the network development process, and it's in relation to the pre-booking of the area, or advancing ourselves and being in a position to supply this particular area. The network development planning process involves a number of stakeholders, from city planning to right up to electricity department within the city, and there are engagements that take place while we are compiling those the plans. And obviously the objective of the plan is to ensure that you are able to roll out and upgrade the network in a systematic way, and ensuring that you are able to comply with the quality of supply requirements as stipulated by NERSA. So now I'm going to also now deal with I think my colleague has dealt with the issue of the greenfield. There was an inspection in loco that took place in February 2022. And there were no arguments on this area being a greenfield. It is a brownfield as per the inspection of logo that was conducted. So I think then there's no debate in that particular issue to say, and NERSA was also part of the process in terms of the inspection in logo that was conducted. I also listened to the submission by the city, where they indicated that there is an application that was submitted to Eskom. I can confirm that there is no application for Mooikloof development as that we received from the city. The application that we are aware of is for Libia's main transmission station that is meant to support the area, city of Tshwane supply area with additional capacity, but there is no application specific to Mooikloof. And my understanding as well, what triggered that application was really the SEZ that is planned within the city of Tshwane, which is closer to our Eerste Fabrieke substation. And also dealing with I want to deal with this issue of available capacity at Nyala. As far as we understand, there was only 16 MVA that was available at Nyala, which is going to be used to supply the SEZ that is in Silverton to Silverton, where now we are also further assisting the city of Tshwane with additional 16 MVA from our substation called ES Fabrike, because there's no sufficient capacity at Nyala. So I'm just surprised to hear that there is additional capacity. If that was the case, there wouldn't have been a request from the city of Tshwane for us to supplement their 16 MVA with another 16 MVA from one of our substations. And just now, the issue of engagements with the developer, I'm just also surprised by the fact that only the engagements are taking place to make supply available to the development. I mean, we have been approached by this developer since it's about 10 years now, almost. There has been engagements. In 2017, there was an application to us for us to provide capacity to this development, and we have obliged, and we attended to that application as per the rules, and the developer then accepted the quotation. So if the city is only engaging this developer now, then it's extremely late because the development is moving. So I think just on that, we are in a position, as you have seen in our submissions, that we do have the existing networks within the area. We are using the capacity that we have at Bashewa substation to supply the initial parts of the development, so that we can support the growth in the area in respect to the capacity that is requested. Thank you very much.
Thank you very much to all the presenters today. I think my closing remarks would be like this, that NERSA finds itself in an untenable position, in the sense that the licensing process is not one of where we're supposed to be adjudicating who has the right to do something. The assumption is that by the time that this process comes to us as NERSA, that all of those processes have been finalized. It is a challenge. We are sitting here with the issues of the Municipal Systems Act, which falls way outside of the ambit of NERSA. It is outside of our jurisdiction. Also, we find ourselves smack in the middle of this long-standing debate about the rights of municipalities, this wall-to-wall. And it's difficult for us as NERSA. I think we are being put in a situation which is, as I've indicated, fairly untenable. We would like to request, I think we will of course, meet as the regulator and discuss this matter further, and to make a decision one way or the other. But it would be useful for us to then be further equipped with all additional information that would be which would assist us in actually arriving at a properly and well constructed and well thought out position. But it is a pity that we find ourselves in this position today, because ordinarily I think we have processes within our constitutional framework and also processes within NERSA that would allow us not to find ourselves in this position. I'd like to thank everybody who participated today, who then clarified the issue before us. Thank Eskom for the application and their presentation on the application. I'd like to thank SALGA for their position and locating the city of Tshwane's objection properly. Also like to thank the city of Tshwane also for their presentation. And then just hope that, I think for us as NERSA, it would be useful if the two parties concerned here, the city of Tshwane and Eskom, could find themselves, so that it will facilitate the licensing, which is really not the process of adjudication of who has the right to supply, whose area it is. this process is not about that. It is about licensing whoever has the right to, and that we like to hope that the two parties will actually find each other and be able to come to NESA with a constructive approach, whether it's an SDA or whatever the processes might be, because at the end of the day here, we have consumers who also have constitutional rights. We cannot forget that we've got consumers here who have a right to be supplied electricity. And the question is, are we not perhaps trampling those rights? With those few words, colleagues, I'd like to then bring this public hearing to a close, and hoping that also there has been learnings from it, from all of us sides. I thank you all. The meeting is adjourned.